Hi, this is immigration attorney Heather Poole. Today we're going to be talking about the green card process in the United States called adjustment of status. There are certain rules to adjustment and there are certain bars to adjustment. In these circumstances, you cannot get your green card in the United States. The first and most prevalent rule is that you cannot get your green card in the United States if you last entered without inspection. Immigration attorneys refer to this as EWI, or entry without inspection. That means that you went through the desert, you crossed through a boat, you were never inspected by an immigration officer. Now, the term inspection and admission, they seem to change and offer a lot of confusion. So if you were waved in at the border through an inspection station but were never asked for any documentation, you may be able to prove lawful admission. You may be able to prove that you were inspected even if you don't have the documents to do so. So always talk to an immigration attorney if there's any way around this particular bar to adjustment. The second common bar to adjustment is if you enter the United States on a temporary visa, such as a visitor's visa, and you're given on your I-94, the white card that you're given at the airport, you're given a particular stay of, let's say, 6 months on average. If you overstay that, they're not going to allow you to adjust your status. The only exception to that is if you're married to a U.S. citizen and you're basing your adjustment based on a filing by that U.S. citizen on your behalf. But everybody else who's applying based on a work offer, no way. You have to consular process. If your most recent entry was on a K visa, K1 in particular, which is someone who is a fiancé of a U.S. citizen, but they decide not to marry that U.S. citizen within the 90 days that they're supposed to, but instead decide to marry somebody else, and then that new husband or new wife sponsors them for a green card, immigration will deny the petition. Because they entered as a K1 fiancé, they can only consular process unless they adjust status based on the person who is now their spouse, who they got through the K1. Any new spouse, they can't adjust. Even U.S. citizens aren't off the hook. Another common bar is if you enter the United States on a C1 crewman visa. You're a member of a ship and you enter the United States. Even if you're married later to a U.S. citizen, that U.S. citizen cannot sponsor you for a green card in the United States. They will deny your adjustment application. You will have to consular process. Now, be very careful with this. There are multiple types of C1 visas. If you have a C1 visa called an in-transit visa, not as a member of a crew in a ship, then you may be able to adjust. Although certain CIS local offices have varying points of view on whether this is true, and you will have an uphill battle. But we have been successful on certain cases, so it really depends on where you live. Similarly, another rule, if you last entered the United States from a visa waiver country, where you do not have to have an actual B2 visa for visiting in your passport, such as from the UK, you're usually given 90 days on your I-94 card. You're usually not allowed to adjust status if you came as a visa waiver. That's the benefit, what you give up in order to come in on a visa waiver without having to apply for a visa at your consulate. The only exception to this is if you are married to a U.S. citizen. But even that is having problems, again, depending on where you live in the country and which CIS office you are submitting your file to. The bars to adjustment can seem pretty harsh. There are a lot of laws, though, that make exceptions. They can be very remote, such as NACARA, temporary protective status for people who have fled to the United States because of war ongoing in their country or because of mass flooding or other kinds of natural disasters. TPS is not a barrier to adjustment. 245I is also an exception to adjustment, and you may qualify under that old law. Lastly, there's Amnesty Provisions from 1980s. There's Registry, which is for people who have lived there for a very, very long time and can show that they've been living in the United States. They also might be able to get around the bars to adjustment. Also, in removal proceedings, there may be ways to get around the bars to adjustment, including cancellation of removal. Asylum and withholding, and 245K is a special provision for those who are here on employment-based visas who wish to adjust. There are exceptions to everything, and as you can see, this is a very complicated area of the law. So what is my suggestion? Talk to an immigration lawyer about your situation. There may be an exception that applies to you. If you would like my help, feel free to give us a call.